This is file 25-22098-FH, People versus Mark Jonathan. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayanetto.
Good morning, Your Honor. Alex Bayanetto for the people.
Your Honor, good morning. Elias Muad appearing on behalf of Mr. Larson.
And Mr. Muad, where do we stand with Mr. Larson's case today?
Judge, we have a plea agreement worked out and signed by everybody. The plea agreement is as follows. Mr. Larson is going to be pleading guilty to added count 2 of attempted accosting for immoral purposes. There is a sentence agreement under paragraph 3 of the plea agreement for no upfront jail. Paragraph 4 of the plea agreement is going to nolly pros count 1. And then Mr. Larson understands under paragraph 9 that the conviction will result in him being required to register under the Michigan Sex Offender Registration Act.
All right, Mr. Bayanetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor, yes.
Mr. Larson, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Mark Jonathan Larson?
Yes.
Mr. Larson, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, attempted accosting a child for immoral purposes?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
Are you satisfied with Mr. Muad and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Bayanetto?
That's correct, Your Honor.
Mr. Muad?
It is correct, Judge.
Is that also your understanding, Mr. Larson?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Larson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime could result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, Mr. Larson, that by entering into this plea, you will be required to register under the Michigan Sex Offender Registration Act?
Yes.
Do you have any questions about any of the rights that I've described to you?
No.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about November 18, 2024 through December 3, 2024, that in the city of Tecumseh, county of Lenawee, state of Michigan, you did commit the offense of attempted accosting a child for immoral purposes?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Larson to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Larson, other than as we've talked about on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty?
Yes.
Mr. Mawad, do you want to establish the factual basis?
Yes, Mark, I'm going to be asking you some questions, and we're going to go to the date between November 18th, 2024 through December 3rd of 2024 in the city of Tecumseh in Lenawee County, okay?
Okay.
All right, did you attempt to commit the following offense? Did you attempt to accost, entice, or solicit an individual that you believe was a child less than 16 years of age with the intent to induce that person to commit an immoral act such as, just hold on 1 minute, such as to have sex with that person that you believe was a minor?
Yes.
Okay. I apologize for the lack of wording. Somebody was calling on my phone and I missed the complaint, but unless Mr. Bayanetto wants to ask questions, I think he meets the elements, Judge.
I'm satisfied, Your Honor.
All right. Mr. Larson, you accomplished that by having some kind of internet or text communication with someone in Tecumseh, Michigan.
Yes.
All right. Has the court complied with MCR 6.302 BC and D, Mr. Bayanetto?
It has, Your Honor.
Mr.
Yes.
Mawad?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Larson has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation interview and set sentencing for May 22nd at 8:15 a.m.
That's fine, Judge.
Mr. Larson, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
I need address and phone number.
Okay, I'm going to put you, Mr. Larson, in a breakout session with Ms. Holly from the probation department so that she can collect your contact information.
Okay.
Mr. Mawad, do you want to be put into that breakout session as well?
No, that's okay. Ms. Holly's going to get his information. No problem, Judge. Thank you.
Okay. She'll also give you instructions on what you need to do next in terms of contacting the probation department, and you can go ahead and log out of the meeting when you're done speaking to Ms. Holly. Okay, Mr. Larson?
Okay.
All right, thank you. And I know Alex signed up, but to the prosecutor's office, thank you very much.
Thank you. Okay, Mr. Casper, are you ready to proceed with Mr. Sarin?
I am, Your Honor.
Steve. Okay, this is file 25-22112-FH versus Brody Raymond. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Bert Casper, man.
All right, and Mr. Castleberry, where do we stand with Mr. Sarin's case today?
Your Honor, you just received the plea offer. We are going to enter into that plea offer.
Okay, do you want to state the terms of the agreement on the record and unless Mr. Bayonetto?
Your Honor, the offer is to dismiss counts 1 and 2 and to plead guilty to count 3 and 4, added count 3 and 4. There is an agreement to have no upfront jail, and count 3 is to be sentenced under the Holmes Youthful Trainee Act.
Okay, Mr. Bayonetto, is that a complete and accurate statement of the agreement?
It is, Your Honor. I didn't know if the court was still streaming to YouTube or not. I don't know if this should be broadcast on YouTube given the plea.
The height of status doesn't apply until it's assigned at sentencing, so I think for purposes of this hearing, it's still a public record. Mr. Sarin, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury? And you are Brody Raymond Sarin?
Yes.
You can put your hand down if you want. Mr. Sarin, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3 on the amended information, which is assaulting, resisting, obstructing a police officer?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or $2,000?
Yes.
Is it also your intention to plead guilty today to count 4 on the amended information, which is operating while impaired?
Yes.
You understand that the maximum possible penalty for that offense is up to 93 days in jail and or $300 fine and or 360 hours of community service work?
Yes.
Are you satisfied with Mr. Castleberry and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with courts that other than as we've discussed on the record here today. Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
Mr. Castleberry?
It is, Your Honor.
Is that also your understanding, Mr. Sarin?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Sarin, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about December 1st, 2024 in Fairfield Township, Lenawee County, Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer?
Guilty.
And how do you wish to plead to the charge that on or about December 1st, 2024 in Fairfield Township, Lenawee County, Michigan, that you did commit the offense of operating while impaired?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges? If I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record here today, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Sarin to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Sarin, other than as we talked about on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be? Is it your own choice to plead guilty today? Mr. Casper, do you want to establish a factual basis?
Okay, Your Honor. Mr. Sarin, on or about December 1st, 2024, were you in Fairfield Township in Lenawee County in the state of Michigan?
Yes.
And were you attending a party?
Yes.
Were you drinking alcohol at that party?
Yes.
What were you drinking?
Beer.
And at some point, did the police break up that party?
Yes.
And did you flee the police and obstruct the police in doing their duty?
Yes.
And as a result of your alcohol consumption, was your ability to drive impaired?
Yes.
I have no further questions, Your
Mr.
Honor.
Van Allen, are the people satisfied with the factual basis?
The only thing I would add, Mr. Sarin, you knew they were police when you ran from them, correct?
Yes, sir.
Okay. I'm satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Van Allen?
It has, Your Honor.
Mr. Casper?
It has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Sarin has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 5th at 8:15 a.m. Mr. Sarin, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background. And if you want to step across the hall to the probation office, they'll have a packet of information to give you and let you know what you need to do next with it.
Was there a PBT or anything?
There
I'm sorry?
was.
Oh.
It was a breath test, and the results were 0.087 and 0.091.
Thank you.
Okay, so Mr. Sarin, you can just step across the hall to the probation department. They'll set you up with what you need to do next.
Thank you.
Thank you, Your Honor.
Hanson Grimes, what case are you here for?
I'm here on behalf of Megan Cooper. I emailed Frances this morning to let her know that I just was subbing in today. I do have a substitution for you to sign. The public defenders didn't get it back to me until after 4:30 last night.
I'm sorry, you said Megan.
Megan Cooper.
If you want to approach, I'll sign.
I sent them and then they faxed me back with their signatures. So I don't know if you want to sign the originals, and I would just say. I don't know which court first. But then I would just note the attached on the original. Ms. Cooper is here, so we're ready when you are, Your Honor.
All right, Ms. Cooper, if you want to come forward, please.
And Your Honor, I am not trying to interrupt the court, but I represent Eric Cooper as well. And I've been in communication with the attorney that is present in court regarding potential dates.
Oh, all right.
Judge, I believe Mr. Cooper's in jail, though.
Okay, you want to call for Mr. Cooper?
Yes, please. Thank you. Bye.
And I believe Mr. Fry is on Mr. Cooper's other case. Ms. White represents him on the 450 or more case, and Mr. Fry is on the other case, the 25 case.
Okay, I've only got one on the docket today, the 25 case. There's a 2024 case as well.
Ms. White is on the 2024 case. Mr. Fry is on the 2025 case. They should both. I thought they were both up today.
Do you have the case, the full case number on the 24 case?
Hang on a second.
I do, Judge. It's 24-22084 FH according to the felony information.
Okay. Okay, so we've called for Mr. Cooper at the jail. So let me do Ms. Cooper's case first. So this is file, oh, sorry. This is file 25-22162-FH People versus Megan Marie Cooper. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold for the
Allison Arnold for the people.
Ashley Hanson-Grimes on behalf of Megan Cooper, who is in the courtroom to my left.
All right, and Ms. Hanson-Grimes, I understand you just substituted in, but where do we stand with the case at this point from your perspective?
As evident by the fact that the court just signed my substitution this morning, and which I received last night from the public defender's office, I have not had any opportunity to talk with Ms. Arnold. I requested any discovery that had been shared with the public defender's office, and I received nothing. And I know that there is lengthy discovery at issue in this case. So I am requesting an adjournment of this pretrial so that I may see something beyond a police report, as my preliminary viewing of a police report that was provided by my client shows that there are some substantial issues of discovery that I would need to follow through with. So I would like to have this matter set for a second pretrial in the month of June if possible, so that I would have time to request my discovery and review that discovery and file any motions that I see fit regarding that discovery.
And Judge, we think that would be appropriate. With Eric Cooper's case, the case that Ms. White is on, there's a delivery causing death charge that we're looking at adding to that file. I'm waiting for one.
Relevance.
Okay, it's a pretrial conference.
I understand, Your Honor,
it's
but
relevant.
we're not talking about Mr. Cooper. I'm not retained on Mr.
That's fine. It's relevant. in the sense that-
My only point was, if we're gonna have, I
Can I
thought
see it,
the
please?
attorneys.
It's relevant in the sense that for purposes of judicial economy, it helps to keep the cases together. I think that Mrs. Arnold is getting to the point that we're trying to get the same date for both cases. So Ms. Arnold, if you have a date suggestion that's been coordinated with the attorney on the other case, I would appreciate that.
Judge, my understanding was based on what the defense attorney said, that they had talked about a mutual date. I'm fine with whatever works with my schedule.
All right.
Would the court like me to suggest a date? I'm happy to do so.
What date would you like?
Would it be possible for us to be back here on June 25th at 8:15?
Ms. White, does that work on your calendar?
Judge, I have a jury, that is the only date in June that I am unavailable. I have a jury trial that's scheduled in the Third Circuit Court. But if the court is available any day prior to that or any week after that, I can make myself completely available to the court.
Your Honor, I have no objection to moving to July 9th, which would be 2 weeks further from that date, and only as I'm unavailable the week of July 4th.
Judge, I am available July the 9th.
All right, let's go with July 9th then at 8:15 a.m.
And I had, I can't remember if I left her, I believe I left Miss Grimes a phone message that said we didn't have her appearance yet. That makes sense. The court hasn't signed a substitution. If Miss Grimes wants to talk to my legal assistant, Tina Johnson, she can send her all the discovery because it's all electronic. If she wants to confirm we got that appearance, it probably makes, although I think the public defender's office should send what they have, it probably makes more sense for us to resend it just to make sure she has everything.
So I just signed the substitution of attorney this morning, so Ms. Hanson-Graf will be able to provide you with a copy once that gets filed with the clerk's office.
And I will do so, Your Honor. I will reach out to Ms. Arnold's office to see if I can secure and also file my request in writing for the court.
All right, is there anything else we need to address with this case today?
Not as it relates to Ms. Cooper. She is out on bond. We request that continue, and she is fulfilling her obligations per her pretrial bond conditions.
I would also say there's a note from Mr. Coast that indicates the same thing, so bond conditions will be continued as they're currently set.
Okay. Thank you.
Thank you.
Thanks, Judge.
Okay, so let's move on. File 24-22084-FH and 25-22161-FH, People versus Eric Lee Cooper. We are here today for pretrial conferences in both of those cases, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the People.
And good morning, Your Honor. May it please this honorable court, Cena Colbert White, P52354, appearing on behalf of Mr. Cooper.
Good morning, Your Honor. Brian Fry appearing for Mr. Cooper in the 25 file.
All right, and we did have a discussion about the next date in this case when we were dealing with Ms. Cooper's case previously, and landed on the date of July 9 for a next pretrial in this case. Is there anything else? I guess, Mr. Fry, let me start with your case, the 24 case. Is there anything else we need to address with that case today?
No, Your Honor.
Ms. White, is there anything we need to address in your case, the 25 case, other than the new pretrial date?
Judge, I believe it's the other way around.
No, I think the judge spoke correctly.
I have the 25 case. Ms. White has the 24 case.
Okay, I apologize.
Yes, Your Honor. I have been in communication with the prosecutor regarding this case, and there is quite extensive discovery that's outstanding. Your Honor, I am preparing a very detailed discovery order that will be filed with the court. My only question is, upon filing that, Your Honor, should that motion be argued on July the 9th, or would the court prefer that we set an actual motion hearing date?
I suppose it would depend upon how long you think you will need for argument. If there's going to be any kind of extensive oral argument, I'd rather not do it on the same date as a bunch of pretrials. And I would ask that you contact the court and schedule a specific time for that.
Absolutely, Your Honor, I will do, and I appreciate the court.
And Judge, I would just state for the record that I believe if Ms. White has discovery in addition to the discovery, if she believes we haven't complied with the discovery demand, I'd ask her just to let me know, and I'm happy to provide that discovery. If there are additional items she wants us to try to get, I'm happy to try to do that, provided it is discoverable. So I just ask that she contact me first. We have an open file policy in terms of discovery, and I'm happy to give her whatever we have.
Thank you, Judge. May I respond very briefly?
Go ahead.
Thank you, Judge. I know that the court speaks through its orders. This is a very serious case. The prosecutor has indicated to me that she anticipates amending the complaint/information on this case. If that is so, then the case would be potentially remanded back to the district court for further proceedings. I would rather file an extensive discovery order, Your Honor, based on the information that's contained in the search warrant affidavit. So I would prefer to file the motion and work with the prosecutor's office as well, Your Honor.
All right, that's fine. If defense would prefer to have a written record of that happening, you can file the motion, and if you can work out a stipulation, terrific. If not, the court will be here to resolve any disagreements that might arise.
Thank you, Your Honor, and I appreciate the court. And if I could just indicate, Mr. Cooper, I will make an in-person attorney visit on Good Friday, April the 18th.
Okay,
Thank you, Your Honor.
Okay, anything else for this case today?
Nothing further, Your Honor.
No, thank you, Judge.
Very good.
Thank you for your time then. Mr. Cooper, you can let the officer with you know that you're done with court for today.
Thank you, and we appreciate the court. Thank you.
Thank you.
Mr. Glazier, I'm sorry, what's your name, sir?
Larry Clark?
Okay. Mr. Glazier, do you need to speak to Mr. Clark?
Yes. Is Isaac present? Is Isaac handling this?
He is not. He is usually in Judge Anselm's court on Wednesday morning, so he's not here.
Okay.
I know who's handling it today for the prosecutor. Looks like Ms.
I am,
McClure's.
and Mr. Glazier, I know Isaac tried to call you yesterday to discuss your request, and didn't get a hold of you.
Oh, okay. Then let me speak with Phoebe for, I guess.
1 second. Mr. Davis, you want to come forward to the podium? This is file 23-21504-FH People versus Ryan Edward Davis. We are here today for arraignment on a summons for probation violation, and we are proceeding today by, in person. And sir, you are Ryan Edward Davis, correct?
Yes, sir.
Mr. Davis, have you received a copy of the request and summons for probation violation?
Yes, I believe so.
The request and summons for probation violation alleges that you violated the terms of your probation by testing positive for THC and cocaine on March 14, 2020. Do you understand that that's the allegation that's been made against you?
Yes.
You had, in this case, pled guilty to one count of domestic violence and one count of aggravated assault. The domestic violence charge has a maximum possible penalty of 93 days in jail and or a $500 fine. The aggravated assault charge has a maximum possible penalty of 1 year in jail and or a $1,000 fine. Do you understand that those are the maximum penalties for the charges that you have been convicted?
Yes, I do.
You are entitled to be represented by an attorney here today and at any other hearings that we have about this. If you cannot afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that?
Yes, I'd like to appoint a lawyer.
Okay. You don't at this point have the ability to pay for your own attorney?
No, sir.
Okay. If you want to take a seat back where you were, as soon as we have a public defender available to speak to you, then I'll set you up with a breakout session on the iPad right outside the door.
I have court downstairs at 11. Is it going to be before then, or?
I would assume it'll be before 11 o'clock. And if it's not, and you need to go downstairs and take care of that, you can go downstairs. Back up here. Thank you. Okay, Mr. Glazer, do you need to speak to Mr. Clark now?
Yes, I do, Your Honor.
Mr. Clark, you want to step outside the door? There's an iPad. Do you think you can get it connected or do you need help?
I should be able to do it.
Okay.
Thank you, sir.
Ms. Mull, you are here for Carlton Evans.
Sorry, Your Honor. Yes, Your Honor, I'm here and we're waiting on Matt Murphy, who's appearing at Judge Anzalone's courtroom right now. So we'll be ready to proceed when Matt arrives.
Okay.
Thank you.
Yep. Someone here logged in with a telephone number, last four digits are 8073. Can you tell me your name?
Michael Santiago.
Okay, 1 second, sir.
Yep.
All right, Mr. Santiago, Mr. Malero's not logged in here yet. He is, I assume, handling cases in front of Judge Anzalone. I'm going to put you back in the waiting room, and as soon as he gets logged in here, we'll bring you back in and call your case.
Okay, thank you.
Thank you. So I don't mind stepping outside and seeing when Mr. Clark went. He should be at the iPad right outside the door. And yeah, okay. That's not. Oh, never mind. Back in. Sorry, he just logged in on it. We're okay. He just logged in on it. Oh, okay. Okay, Mr. Clark, I'll put you in a breakout session with Mr. Glazer right now.
Thanks, sir.
Yeah.
Oh, I'm sorry, I screwed that up. 1 second, Mr. Glazer. Okay, sorry, Mr. Clark, I made a mistake trying to set that up. Give me one more chance to do that.
All right.
Yeah, that's why I've been at home. I haven't been nowhere. Can't get moving. It's been rough. I'm hoping I-
Mr. Dagger Margosian, I think I have Mr. Nelson logged in now. Do you need to speak to him?
No, Your Honor, thank you.
Can you hear me?
Yes, we can hear you, sir.
Yes, sir.
This is file 25-22150-FH, People of State of Michigan versus Milo Edwin Nelson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I ask the attorneys to place their appearances on the record, beginning with Ms. McClure for the people.
B. McClure, map the people.
Your Honor, Michael Dagger Margosian for Mr. Nelson.
Okay, Mr. Dagger Margosian, where do we stand with Mr. Nelson's case today?
Your Honor, there are a few further discovery issues that I'd like to review with Mr. Nelson. If it's okay with the court, I'd ask for an adjournment today.
Ms. McClure, anything we need to address from the people's side?
Nothing on behalf of the people.
Mr. Dagger Margosian, how far out were you looking?
Maybe 30 days.
We can do May 7th at 8:15 a.m.
That works, thank you.
Okay, and Mr. Dagger Margosian, would you do a stipulation in order for that adjournment, please?
I will, yes.
All right, if there's nothing else we need to address today, Mr. Nelson, you can go ahead and log out.
Thank you.
Mr. Glazer, are you ready to proceed with Mr. Clark?
Yes, Your Honor.
Clark, you want to come forward? You can stand at the podium. This is file 24-22077-FH, People versus Larry Clark. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B. McClure, map the people.
John Glazer on behalf of Mr. Clark.
And sir, you're Larry Dean Clark, correct?
Yes, sir.
Okay, Mr. Glazer, where do we stand with Mr. Clark's case today?
Your Honor, we're going to ask for an adjournment. I talked to Isaac, I don't know, Mr. Sneed probably a week or so ago, and suggested that Mr. Clark take a polygraph, and I thought he was going to set that up. He responded to me saying that he had changed the situation, or the police said, and they weren't going to give him a polygraph, but we could set one up privately. So we need to set up a private polygraph, and I'll probably can get it done in 3 or 4 weeks.
All right, Ms. McClure, what is the people's stance on that request?
Just to clarify that my understanding is Mr. Sneed did reach out to the police agency investigating, and they were not interested in offering Mr. Clark a private polygraph. But that obviously Mr. Glazer's choice. If he wants to put him on a private polygraph, he's willing to do that. By statute, this is not one of the cases where we have to offer a private polygraph. So I just want to make the record clear on that. But otherwise, we have obviously no objection if Mr. Glazier wants to do a private one, and we can go from there. I will say the offer on this case, as this is a possession of meth, I believe this is his second offense, so there is some 404B evidence that's potentially admissible. And Mr. Sneed's offering him to plead without his subs, and that the sentence would run concurrent with his violation of probation. The maximum he can get on his violation of probation is 1 year. So the most he could get on even this case is 1 year. So that is the offer going forward. But obviously, if Mr. Glazier wants the polygraph before he considers that, I just wanted to make sure the record was clear as to what was going on and what Mr. Clark's options are.
Okay. And I'm sorry, Mr. Glazier, you said 3 or 4 weeks. You
Yeah,
thought
we use a guy up in Lansing, and it will, just to make sure, I would say 3 or 4 weeks.
Okay. Let's then set this for a pretrial on May 7th at 8:15. And the court will vacate the trial date currently scheduled for April 17th.
Mr. Clark, like I said, set up an appointment to see me either Friday or the first part of next week.
Yes, sir. Absolutely.
All right. We don't have anything else, Your Honor.
Okay, Mr. Glazier, would you do a stipulation in order for that adjournment, please?
Yeah, I can do that.
All right. All right, so you are all set for today, Mr. Clark.
Thank you, Your Honor.
All right, thank you, Your Honor. That's all I have with you. I'll see you later.
Okay, thank you, Mr. Glazier.
Thank you.
Could you give it to Bob? Bob, could you have? Oh, I'm sorry. I'm sorry. Never mind. Full slide. Again. All right, Mr. Murphy, I do have Mr. Betts here. Do you need to speak to him?
Yes, Your Honor. I'll need to speak to Mr. Betts.
Okay, I'll also tell you that Jennifer Allen is not present. She's not here in the courtroom. She's not logged into Zoom.
All right, Your Honor. Thank you.
I'm here, Your Honor. Sorry about that.
Okay, are you on the Betts case as well?
I am not.
Okay. Mr. Betts, if you give me one moment, I'm going to place you in a breakout session with Mr. Murphy.
All right.
Actually, I am, Your Honor. I apologize. I'm in too many places.
Can you hear me?
Yeah, 1 second, sir.
Oh, all right.
Morning, Matt.
Mr. Dagger Margosian, I do have Mr. Gerbers here. Do you need to talk to him?
No, Your Honor, thank you.
Okay, this is file 24-22092-FH People versus Tracy Michael Gerbers. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorney's place their appearance on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the people.
Your Honor, Michael Dagger Margosian for Mr. Gerbers.
All right, and this is a final pretrial conference today ahead of a jury trial scheduled for April 16th and 17th. Mr. Dagger Margosian, where do we stand with the case today?
Your Honor, we've reached a resolution with people. We will be resolving it by way of plea, and we can put that on record now.
Okay, go ahead.
Your Honor, this will be a no contest plea to count one. There is a further agreement that there will be no additional criminal charges stemming from this investigation. And lastly, there is a sentencing agreement for no upfront incarceration. I think that's the total agreement today.
All right, Mr. Bayonetto, is that a complete and accurate statement of the plea agreement?
That is, Your Honor. I did send that over to Mr. Dagger Margosian this morning. We were able to resolve the case. The only thing I would add is in paragraph 9 on that plea agreement. It does provide notice that the defendant would have to register under the Michigan Sex Offenders Registration Act as a result of this conviction. Speaking with Mr. Dagger Margosian, I'm sure that's been relayed to him. I just want to make sure that is clear on record before we go forward with the plea.
I've reviewed that with my client as that's part of the Michigan law under this conviction. That's true. That's correct.
Okay. Mr. Gerbers, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Tracy Michael Gerbers, correct?
Yes.
Mr. Gerbers, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count one, accosting a child for immoral purposes?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $4,000 fine?
Yes.
Did you say yes, Mr. Gerbers?
I'm sorry, give me 1 second. Just had a device that some background noise was causing some problems with. So did you say yes, Mr. Gerbers?
Yes.
Okay. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court, other than as we discussed on the record here today. Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Gerbers?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Gerber, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you also understand, Mr. Gerbers, that by entering into this plea, you will be required to register under the Michigan Sex Offender Registration Act?
Yes.
Do you have any questions about any of the rights that I've described to you?
No, sir.
Do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about December 4, 2024, in the city of Tecumseh, county of Lenawee, state of Michigan, that you did commit the offense of accosting a child for immoral purposes?
Say that again. I'm sorry.
How do you wish to plead to the charge that on or about December 4, 2024, in the city of Tecumseh, county of Lenawee, state of Michigan, that you did commit the offense of accosting a child for immoral purposes?
Guilty, I guess.
No contest, Mr. Gerbers?
No. Yeah, no contest. Yeah. That's
okay. Has
sorry.
anyone made any threats or promises to you to induce you to plead no contest to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yeah.
I'm sorry, I didn't hear that.
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Gerbers to plead no contest?
No, Your Honor.
No.
Sorry.
Mr. Gerbers, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here this morning?
No.
Is it your own choice to plead no contest today?
Yes.
Okay, Mr. Banetto or Mr. Dagmar-Gozine, how are we establishing the factual basis?
Your Honor, I've talked with Mr. Baynard. If you could put the facts on record.
I can do that, Your Honor.
Okay.
Your Honor, reading from Tecumseh City Police Department report number 240004106, authored by Officer Samuel Spicer. Had this matter proceeded to trial, the people would have proven beyond a reasonable doubt that in the period between November 12th of 2024 and December 4th of 2024, the defendant, Tracy Gerbers, did engage with a decoy that was employed with the company Pretrials Investigation. That is a private internet-based video production company that targets what they classify as child predators. Mr. Gerbers did engage in text message conversations with a decoy employed by the Pretrials Investigation company. In those text messages, the decoy did indicate to Mr. Gerbers that she was 13 years old. Throughout the series of conversations, Mr. Gerbers did indicate that he would like to engage in sexual activity with the decoy, specifically wanting to have sexual relations with her when he stayed at her home on December 4th of 2024. Your Honor, on December 4th of 2024, in conjunction with the Tecumseh City Police Department, the individuals involved with that Pretrials Investigation company did set up a home in which Mr. Gerbers did come to on December 4th. when Mr. Gerbers was encountered there by police, he did have a variant of Viagra with him. Your Honor, given those facts, I do believe that that does satisfy the elements of accosting a minor for an immoral purpose, and that Mr. Gerbers believed the individual he was communicating with was under was a minor, and again was propositioning that minor for sexual relationship. Given those facts, Your Honor, I think the elements are satisfied.
All right, Mr. Dagger-Margosian, does the defense agree that that set of facts, if proven, would satisfy the elements of the offense?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Vanetta?
It has, Your Honor.
Mr. Dagger-Margosian?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Gerbers has had full knowledge of his rights, and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will, other than as we talked about on the record here this morning, I will refer this matter to the probation department for a pre-sentence investigation interview and set sentencing for June 5 at 8:15 a.m. Mr. Gerber, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
I'm going
his
to
address.
put you, Mr. Gerbers, in a breakout session with Ms. Holly from the probation department so that she can collect your contact information and let you know when you need to report.
Your Honor, may I join that breakout room?
Yes, I will include Mr. Dagger-Margosian in that as well.
Okay. Yes, I.
Okay, Mr. Murphy, are you ready to proceed with Mr. Betts?
Yes, Your Honor.
This is file 25-22122-FH, People versus Jonathan William Betts. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can we have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Betts.
And Mr. Murphy, where do we stand with Mr. Betts's case today?
Your Honor, at this time, there has been a plea offer by the people for Mr. Betts to plead to count 1 and count 3, or I'm sorry, count 5, count 1 being fleeing third degree, and count 5 being operating while intoxicated, dismissing the remaining counts, and that would be without any habituals. I don't know if that was applicable or not. But Mr. Betts did want to accept that plea, and again, plead guilty to count 1, fleeing and eluding third degree, and count 5, operating while intoxicated.
Okay, Ms. McClure, is that a complete and accurate statement of the agreement?
Yes, and I do just want to place on record, per statute under count 1, after a conviction is entered, the Secretary of State will suspend his license for 1 year to make sure he understands that. And additionally, I did not put it on the plea form, but we're reaching out. I haven't gotten an answer yet, which is why I didn't put it on the plea form. I think there's fees for the vehicle being impounded that the victim of or the owner of the vehicle would be asking for restitution for. So that may come up at sentencing. So I just want to make sure both Mr. Murphy and Mr. Betts were aware of that. Obviously, we're dismissing the unlawful use of the vehicle pursuant to the plea, but I would just ask that restitution be reserved on that.
Mr. Betts, you understand that? Do you want to talk to me in a breakout about that?
Yeah, yeah.
Yeah, I'm sorry. Could I have a minute to speak to Mr. Betts?
Yeah, 1 second. Okay, we have Mr. Murphy and Mr. Betts back from the breakout session. Mr.
Thank you, Your
Murphy.
Honor. Thank you, Your Honor, for that breakout session. Mr. Betts wants to continue with the plea at this time.
Okay.
And the other part of the plea agreement that wasn't placed on the record is that we did agree to no initial incarceration. I believe as long as he's complying, continuing his treatment. It was my understanding he's at the Hope House or some other inpatient facility at this time.
Yes, he's currently at, it's Hope House, right, Mr. Betts?
Yeah, yep.
And you'll be there for at least another few more weeks, maybe like 3 or 4 more weeks.
Yeah, the out date says the 28th,
Okay.
but I could get
So
out before then. That's just like an estimate. So
as long as he completes that program and doesn't leave voluntarily or fail at that program, we would agree to no initial incarceration, which we should have an answer to by the time we get to sentencing.
All right. Mr. Betts, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
yes, Your Honor.
And you are Jonathan William Betts?
Yes, Your Honor.
Mr. Betts, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, third-degree fleeing a police officer?
Yeah, yep. I did take off in the vehicle.
Hold
Yeah.
on, just hold on.
Okay. You understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $1,000 fine.
Yes, I understand.
Do you also understand that that requires the Secretary of State to suspend your license for 1 year?
Yes, I know that.
Is it also your intention to plead guilty today to count 5, operating while intoxicated?
Yes.
You understand that the maximum possible penalty for that offense is up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service work?
Yes, Your Honor.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Ms. McClure?
That's correct.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Betts?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial. And if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Betts, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor, I understand.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yeah, I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about January 12, 2025 in the city of Adrian, county of Lenawee, that you did commit the offense of third degree fleeing a police officer?
Yeah, hold on. Trying to push the volume. Yeah, I would like to take the plea.
No, you have to say plead guilty or not guilty.
Oh, you plead guilty, right?
Okay. And how do you wish to plead to the charge that on or about January 12, 2025 in the city of Adrian, county of Lenawee, that you did commit the offense of operating while intoxicated?
Guilty.
Has anyone made any threats or promises to you, Mr. Betts, to get you to plead guilty to those offenses?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on record this morning, or that it was not your own choice to enter those pleas?
Yeah, I understand.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Betts to plead guilty today?
None, Your Honor.
No, Your Honor.
Mr. Betts, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record today?
Yeah, I talked to him.
And did we discuss anything different than what was discussed on the record, Mr. Betts?
No.
Okay. Is it your own choice to plead guilty today, Mr. Betts?
Yeah.
Mr. Murphy, do you want to establish the factual basis?
Yes, Your Honor. Thank you. Mr. Betts, were you indeed in the city of Adrian, the county of Lenawee, the state of Michigan on January 12th, 2025?
Yes.
Okay, and on that day and time, were you operating a motor vehicle on a public highways throughout the county of Lenawee?
Yes.
And while you're operating that motor vehicle on those public highways, were you under the influence of a combination of fentanyl and marijuana to the point where it intoxicated you and impeded your ability to drive?
Yeah.
And while you're operating that motor vehicle, did a police officer, a Deputy Scott, in a fully marked police vehicle try to pull you over with their overhead lights and sirens?
Yeah.
And did you disregard and accelerate away from that officer?
I did.
And would you agree that during that period you went through areas where the speed limit was 35 miles per hour or less?
Yeah.
Your Honor, I believe we established the factual basis. I didn't know if Ms. McClure had anything further.
My only follow-up would be to agree or stipulate that that was a 2008 Ford Ranger belonging to another individual, and that vehicle had to be impounded as a result of these actions.
Is that correct, Mr. Betts?
Yes.
I'm
you.
satisfied, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
It has, Your Honor. Thank you.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Betts has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, and anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 6th at 8:15 a.m. Mr. Betts, someone from the probation department will be in touch with you to do a pre-sentence investigation. When you do that interview, please be truthful about these offenses and about your background.
All right.
I am going to put you in a breakout session now with Ms. Holly from the probation department so she can collect your contact information and give you some instructions on what you need to do next. And you can go ahead and log out as soon as you're done speaking to Ms. Holly.
Wait, is it gonna pop up on here?
Yeah, 1
Oh,
second.
never mind. All right, I see it.
Mr. Betts, after you're done and you log out, just contact me in a few weeks and let me know what's going on with. Oh, never mind.
He had already moved himself.
I'll contact him. Thank you, Your Honor.
Okay. All right. And Carlton Evans is here. Do you need to speak to him?
I think we're ready to proceed on the record, Your Honor. Ms. Mall had said, I mean, she's been handling the case predominantly, and she said that we're ready to proceed, I believe.
That's correct, Your Honor.
This is file 25-22157-FH. People versus Carlton Benjamin Evans. We are here today for a pretrial conference and proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Julianne Mull with an on.
Oh, sorry. Go ahead, Joey. Go ahead.
Julianne Mull with and on behalf of Carlton Evans.
Matthew Murphy appearing on behalf of Mr. Evans.
All right, and sir, you are Carlton Evans, correct?
Yes.
Ms. Mull, where do we stand then with Mr. Evans' case today?
Yes, Your Honor. Mr. Evans is going to accept the plea as charged to count 1, operating while intoxicated.
All right, Mr. Evans, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
You can put your hand down. And you, again, you are Carlton Benjamin Evans, correct?
Yes.
Mr. Evans, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, operating while intoxicated?
Yes.
Do you understand that the maximum possible penalty, I'm sorry, that's a 3rd offense, correct?
Yes, sure.
That's correct.
Okay. So that's operating while intoxicated, 3rd offense. Do you understand that, Mr. Evans?
Yes.
You understand that the maximum possible penalty for that offense is a fine of $500 to $5,000 and either 1 to 5 years incarceration or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service.
Yes.
Do you understand that that also requires mandatory vehicle immobilization for not less than 1 year or more than 3 years?
Yes, Your Honor. Oh, I'm out.
Are you satisfied with Ms. Mull and the advice that she's given?
Yes, Your Honor.
Neither the prosecutor, defendant, nor anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Bayanetto?
That's correct, Your Honor.
Ms. Mull?
That's correct, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now, Mr. Evans, to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Evans, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes. Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, I do not.
Do you understand that you're giving those rights up?
Yes, I do, Your Honor.
How do you wish to plead to the charge that on or about December 15, 2024, in the city of Tecumseh, county of Lenawee, state of Michigan, that you did commit the offense of operating while intoxicated, third offense?
Guilty.
Has anybody made any promises or threats to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the board on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Evans to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Evans, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, it is.
Ms. Mull, do you want to establish a factual basis?
Yes, Your Honor, I'm ready to do that. Carlton, you can keep the voice on for a few minutes. I'm going to ask you a few questions. On December 15th, 2024, at approximately 12:10 a.m., were you in the city of Tecumseh, county of Lenawee, state of Michigan?
Yes.
And at that time, were you driving a motor vehicle on West Chicago Boulevard in Tecumseh?
Yes.
And had you had consumed alcohol before driving?
Yes.
And did that alcohol cause you to become intoxicated and negatively impacting your ability to drive?
Yes.
And was a blood draw of your blood completed and revealed a blood alcohol content of 0.288?
Yes.
And had you previously been convicted of operating while intoxicated on May 1st, 2002 in Bowling Green Municipal Court?
Yes.
And on August 11, 2004 in Sylvania Municipal Court?
Yes.
And on October 3rd, 2011 in Sylvania Municipal Court?
Yes.
Your Honor, I believe it's met.
Mr. Bannon, are the people satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bannon?
It has, Your Honor.
Ms. Mullen?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Evans has had full knowledge of his rights and he has had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation interview and set sentencing for June 6th at 8:15 a.m. Mr. Evans, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, Your Honor.
And I am going to place you in a breakout session with Ms. Holly from the probation department so she can collect your contact information and give you some instructions on what happens next.
Thank you.
I was still in the breakout room before, so I missed the whole plea. I don't know what he pled to.
Sorry, he pled to count 1 as charged.
Is there an agreement?
There's no sentencing agreement.
Okay. Okay.
Ms. Mull, do you want to be a part of that breakout session?
Sure. Thank you.
Okay. One second. Okay, Ms. Underwood, we'll call for Mr. Molina right now. In the meantime, I have Mr. Davis here who had a probation violation summons and requested a public defender. So Mr. Davis, if you want to step outside, there's an iPad on a stand right outside the door. You just need to stand in front of that and I'll put you in a breakout session with Ms. Underwood. Ms. Underwood, you need to unmute your device.
The last name again, Your Honor.
Davis.
Thank you.
Okay, let's see, Mr. Murphy.
Your Honor, Jennifer Allen, I haven't been able to reach her. Last I knew, she was trying to get into an inpatient rehab, but I haven't got any word about that situation. She appeared in district court at the last time she had a district court case down there. I'm trying to find the date of that, but that was the last time I'd seen her or talked to her.
Okay.
And Judge, part of her bond condition, she's supposed to be doing 2 times a week drug testing. She has yet to do a single test. I've left her a couple messages and she's never called me back.
Okay. Do you have Mr. Smith also, Mr. Murphy?
Matthew Smith? I do have Matthew Smith.
Yeah, sorry, one second. I'm sorry, Mr. Davis, I clicked the wrong button. Let me fix that. Should be set now, Mr. Davis. Okay, and I'm sorry, you said you do have Mr. Smith?
I do, Your Honor.
Okay. Do you need to talk to him?
I think we're ready to proceed. I think we have a plea worked out, even though it's only the arraignment. I think if we haven't sent it over, we can send over the signed.
Let's see, I have an amended information.
I sent over an unsigned plea agreement, just for the court's benefit, but I don't believe we have the signed one.
Okay, I'm fine as long as the signed one catches up.
Yeah, we'll get that to you if not already.
Okay, so this is file 25-22207-FH People versus Matthew David Smith. We are here today for an arraignment. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B.B. McClure, on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Smith.
And sir, you are Matthew David Smith, correct?
Yes, sir.
Mr. Murphy, does Mr. Smith wish to have the information read?
No, Your Honor, we acknowledge receipt of the information and the amended information, the witness list, and the discovery demand by the prosecution in this matter. We do have a plea agreement worked out, so we would ask the court if we could enter it and accept the plea agreement today. I didn't know, I didn't have anything further to talk to Mr. Smith about, but did you want to talk to me in a breakup before we proceed with the plea, Mr. Smith?
Yeah, can we talk for a second?
Your Honor, may we have a minute? I'm sorry.
So I have crossed it, doesn't list it. Put it. Okay, Ms. Underwood, are you ready to proceed with Mr. Davis?
Yes, Your Honor.
Okay, Mr. Davis, you can come forward. So this is back on the record, file 23-21504-FH, People versus Brian Edward Davis. Mr. Davis has had the opportunity to speak to Ms. Underwood from the Public Defender's Office. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Davis, Your Honor. I understand this is a show cause. I do not have the documentation, but I have discussed it with Mr. Davis. We would ask that this matter be set out a week or two, Your Honor, for us to more fully discuss it. And it will be resolved at that time, I believe. We have discussed it. I don't have a copy in my hand. I was not sent it, or at least I can't find it.
Okay.
Yeah, Rhonda, you're going to get that show cause from Mike McCarron.
We'll make sure it gets sent over to you today, Ms. Underwood. Mr. Davis earlier mentioned a hearing in district court. I don't know if you were aware of that, and I have no idea whether it's related to this or not related to this. And so I don't know if you want to speak to him again, if we need to wait until something else gets resolved, or I can just put it on the calendar for 2 weeks from today.
You can put it on the docket for 2 weeks from today, Your Honor. Mr. Davis made me aware of the district court situation.
Okay. All right. So that would be April 23rd at 8:15 a.m. So that'll be your next date, Mr. Davis, and you can do that either in person like you did today or by Zoom if you want. So
Thank
you're
you.
all set with us for today. Okay, gentlemen at the jail, are you Mr. Molina?
Yes, sir.
Ms. Underwood, you need to speak to Mr. Molina.
Just for a second, Your Honor.
Okay, 1 second. Set that up. Okay, Mr. Murphy, are we ready to proceed with Mr. Smith then?
Yes, Your Honor.
Okay, back on the record in file 25-22207-FH, People versus Matthew David Smith. And Mr. Murphy, how are we ready to proceed today?
Your Honor, Mr. Smith is ready to take the plea offer from the people in this matter, which would include, again, him pleading to attempted breaking and entering with intent. We will have to use the elements of the greater to satisfy the lesser in this matter. And on the plea agreement as well is from the people here is that Mr. Smith is currently in Hillsborough County Drug Court, and the people agree to no upfront incarceration as long as he continues successfully in Hillsborough County Drug Court and doesn't get violated out of that drug court. So again, he does wish to accept a plea today and enter a plea of guilty to attempted breaking and entering with intent.
Okay. Excuse me. Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, and I noticed Mr. Murphy mentioned that we would have to take the elements of the greater to satisfy the lesser. I think that would be a little bit tricky in this case, as the attempted B&E is not a lesser of the possession of burglar tools, but I think from the evidence in the case and through discovery, I think we can make out a factual basis for the attempt B&E with intent. And I think Mr. Smith, as long as he's okay with that factual basis, should be able to tell us exactly. It was our theory of the case that he did in fact attempt or did break into a barn. So I think with that understanding, we can move forward with the plea with that factual basis.
Yeah, we'll try to establish the factual basis for that. If there's any issue with that, then we'll just continue with whatever happens from there. So.
And then for Miss Holly or whoever's going to take the case's benefit, he is currently being supervised in Hillsdale. And I did speak with his probation officer there who supervises their drug court. And they've indicated that he is doing well in their drug court and doing well on supervision.
Okay, Mr. Smith, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Matthew David Smith?
Yes, Your Honor.
Mr. Smith, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, attempted breaking and entering a building with intent?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison?
Yes, Your Honor.
Neither the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them have discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Ms. McClure?
That is correct.
Yes, oh, sorry.
Mr. Murphy.
That's correct, Your Honor.
Is that also your understanding, Mr. Smith?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Smith, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about September 29, 2022 in Cambridge Township, Lenawee County, Michigan, that you did commit the offense of attempted breaking and entering a building with intent?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record here today, or that it was not your own choice to enter that plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Smith to plead guilty?
No, Your Honor.
Ms. McClure, are you aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Smith to plead guilty?
No, Your Honor.
Has Mr. Smith, has your attorney promised you any particular sentence or estimated what your sentence would be?
Just what the plea bargain,
Other than as we've discussed it here today, has he promised you any particular sentence or estimated what it would be?
No, Your Honor.
Okay. Is it your own choice to plead guilty?
Yes, Your Honor.
All right, Mr. Murphy, do you want to establish the factual basis?
Yes, Your Honor. I'll try to establish factual basis, then Ms. McClure can correct or update if necessary. So, Mr. Smith, can you hear me okay?
Yes, sir.
Okay, so on or about September 29th of 2022, were you in the Cambridge Township, County of Lenawee, State of Michigan?
Yes, sir.
Okay, were you at an address of 13146 US Highway 223?
Yes, sir.
Okay, and at that location, did you have in your possession some bolt cutters?
Yes, sir.
Okay, and were you intending to go into a barn and storage units or storage units with either making use of those bolt cutters with the intent to take items out of those buildings?
Yeah. Yes, sir.
Okay. I guess I'm satisfied with the factual basis, John. I'm not sure what further Ms. McClure wanted to
Nope. I'm satisfied. Thank you.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Murphy?
It has, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Smith has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 6th at 8:15 a.m.
Thank you, Your Honor.
They said,
Mr. Smith, I'm sorry.
Yes, sir.
Mr. Smith, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir.
And I'm going to put you in a breakout session with Ms. Holly from the probation department so that she can collect some information from you and give you some instructions on what happens next.
Okay, thank you.
What happened to the habituals? Are the
Those are-
habituals being dismissed?
Yes.
Yes. Oh,
Okay.
sorry.
Okay.
Okay, Ms. Underwood, are you ready to proceed with Mr. Molina's case?
Yes, Your Honor. Thank you.
This is file 14-16856-FH and 25-22179-FH. People of the state of Michigan versus Robert Paul Molina. The 14 case is set for a hearing on a violation of probation. The 25 case is set for a pretrial. First, can I have the attorneys place their appearance on the record, beginning with Ms. Williams for the people.
Morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Rhonda Underwood on behalf of Mr. Molina this morning, Your Honor. Thank you.
All right, and Ms. Underwood, where do we stand with Mr. Molina's cases today?
Your Honor, at this point, I think Mr. Molina is going to plead guilty to the violation, Your Honor, and we would ask that the new matter be set for another pretrial.
Okay, so we'll set the new matter, the 25 case, for a pretrial on May 7th at 8:15. And back to the violation of probation. Mr. Molina, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Robert Paul Molina?
Yes, sir.
Mr. Molina, do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes, sir.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes, sir.
And do you understand you're giving those rights up?
Yes, sir.
How do you plead to the charge or the charge that you violated the terms of your probation by failing to make payments during your probation and having an outstanding balance of $77,575.88 as of March 4, 2019?
I plead guilty.
All right. And so there was also a warrant based on a failure to appear. Do you understand that you have a right to contest that charge as well?
Yes, sir.
Do you understand that you have a right to a trial on the failure to appear also?
Yes, sir.
You understand that throughout that trial on the failure to appear, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, sir.
Do you understand that you would have all those same rights that I just described to you regarding the right to remain silent and not have that used against you, or also to testify if you wanted to testify?
Yes, sir.
And you'd also have the right to be presumed innocent, which I've already described. And you'd have the right to have any of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me or any witnesses after your defense to appear at your trial. Do you understand all of that?
Yes, sir.
And how would you like to plead to the failure to appear?
Guilty, Your
You
Honor.
understand that by pleading guilty to both of those charges, you're giving up your right to a trial and the right to have your lawyer's assistance at that trial, as I've already explained.
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anybody threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
So in the 14 case, you were placed on probation back in May of 2014. Is that correct?
Yes, sir.
And one of the conditions of your probation was that you make payments on your child support. Is that right?
Yes, sir.
And at the time that you were placed on probation, according to the order of probation, you owed $74,070.62 in child support. Is that correct?
Yes, I believe so.
And at the time the summons was issued in 2019, the amount of child support that you owed was $77,575.88. Is that correct?
Yes, I believe so.
And so a summons was issued directing you to appear in court on March 27, 2018 at 8:15 a.m. Is that correct?
Yes, sir.
And you did not, in fact, appear in court on that date. Is that right?
That's also correct.
All right, I'll accept the plea then. They have been given understandably, voluntarily, and accurately. Mr. Molina has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of plea or sentence in the case. I will refer this matter to the probation department for an update of your pre-sentence investigation and set sentencing for April 18th at 8:15 a.m. Is there, Mr. Molina, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay. I will.
Anything else we need to address with these cases today, Ms. Williams or Ms. Underwood?
I don't believe so, Your Honor.
From the date, April 15th at 8 a.m. for the sentencing?
Sorry, I missed the first part of what you said, Ms. Williams.
Sorry, April 15th at 8 a.m. 8 a.m.
Oh, the sentencing date was April 18th at 8:15.
8:15. Okay, thank you.
Your
That's
Honor,
all for the
I'm
people.
sorry. Would you like me to do the stip order for the pretrial?
Yes, please, and thank you for remembering that.
Miss Williams, may I do that with your permission?
Yes, you may.
Thank you.
Thank you.
Okay, I think we're all set with that one for today. Then, Mr. Molina, you can let the officer with you know that you're done with court.
All right, y'all have a good day.
Thank
Thank
you.
you. Ms. Underwood, do you need to speak to Mr. Dillard?
Yes, please.
Okay, let's. This is file 25-22155-FH and 25-22156-FH, People versus Jennifer Lynn Allen. We are here today for pretrial in both of those cases, as well as hearing on, there's a pending contempt that from the district court file that came up with this. There's also a show cause in the 25-22156-FH file that was scheduled for today. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
PB McClure, map of people.
Allen?
And the record should reflect this matter was set for hearing this morning at 8:15 a.m. It's now 10:14 a.m. Ms. Allen is not present here in the courtroom. She has not logged into the Zoom session, nor has she been at any point this morning. Mr. Murphy, is there anything you'd like to say with respect to Ms. Allen?
Your Honor, I haven't spoken with Ms. Allen. I tried to call her yesterday and this morning. Last I had known, she had appeared in district court a couple of weeks ago, and she'd indicated she was trying to get into an inpatient rehab, but I haven't heard from her since then.
All right, Ms. McClure, anything to add from your perspective?
No, I was just reviewing the notes and I don't have any other information to add.
And Mr. Coast, where do we stand with Ms. Allen in terms of complying with her bond conditions?
Judge, she hasn't complied. She has yet to do a single drug test. I do have a show cause where it was mailed to her, and in that show cause, I told her that she needed to be here in person, which obviously she's not. I've also tried her phone a couple of times, and I've not received a phone call back. So I have not heard from her, and that's where I'm at.
Okay, it does not look like she has a prior failure to appear. At this point, I will give her the 48-hour grace period, and if we do not hear from Ms. Allen in the next 48 hours, I will issue a bench warrant at that time and set bond on that bench warrant in the amount of $15,000 cash or surety in each file.
Yes, Your Honor.
Thank you, Your Honor.
Okay, gentlemen at the jail, are you Mr. Owen?
Mr. Raymond.
Oh, Mr. Raymond, I'm sorry. Okay, Mr. Raymond, Ms. Underwood is working with another client right now. As soon as she's done with that person, I'll have you speak to her.
Okay, thank you.
And I'm sorry, Mr. Murphy, did you represent Mr. Owen?
Yes, Your Honor. It's an arraignment and we wanted to argue bond.
I have a second. See, I've got both rooms full right now. All right, as soon as we get a room available, we'll call for Mr. Owen.
Thank you, Your Honor.
This is file 24-21905-FH People versus Zachary Dillard. We are here today for a probation violation hearing, and we are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Dillard, Your Honor.
All right, and where do we stand with Mr. Dillard's case today?
Your Honor, can you repeat that file number again for me?
24-21905.
Thank you. Then, Your Honor, I've obtained a copy of a nole filed in this file last year, Your Honor.
Yeah, it's a probation violation. So he pled in October 2024 to possession of methamphetamine.
But we can't have probation to a file that's been noled.
What's the date of it?
Hang on. Your Honor, could I screen share with you briefly?
I just need to know the date it was filed.
Okay. Filed December 23rd, 2012.
Okay, yeah, I've got it. That Nolly Pross dismissed counts 1 and count 2. Mr. Dillard pled guilty to count 3, and he was sentenced on count 3 to probation.
Okay.
This is an alleged violation of that probation.
Okay. All right. Thank you.
All right, and so how does he want to proceed with respect to the probation violation?
Well, Your Honor, we were expecting charges downstairs, but thus far, Mr. Dillard does not have a court date for those. You know, but I don't want him in jail on this any more than he should be, because it's a technical violation. Well, it was a technical violation. Okay. Okay. Mr. Dillard. Perhaps we should do another brief breakout, Your Honor.
Okay.
Oh, but I can get the original back. Okay, okay.
Sir Claro, do you need to speak to Mr. Santiago?
Probably not. Not really.
Hello? Hello?
Okay, 1 second. 1 second, Mr. Santiago.
Okay.
This is file 24-21935-FH People versus Michael Ramon Santiago Sr. We are here today for a final pretrial conference in this case ahead of a trial date set for April 15th at 9 a.m. We are proceeding today by video conference. Mr. Santiago is participating by telephone. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Salvatore Malero on behalf of Michael Santiago.
And Mr. Malero, where do we stand with Mr. Santiago's case today?
Your Honor, Mr. Bayanetto and I have been trying to see if we could get to resolution. Also, in preparation for trial, I think. If Mr. Bayanetto, I speak out of turn, let me know. But I think we're not in a position to go to trial on this case next week. And so I would ask to adjourn this. There's certain issues that I think evidentiary issues for him and I need to resolve with respect to certain exhibits. And so I don't believe we would be prepared to go forward. So I would be requesting to adjourn the matter.
Mr. Bayanetto.
Your Honor, I wouldn't have any objection to an adjournment. Mr. Malero is correct. I put in a request with the Michigan State Police to have the records for the intoxilizer that performed the test for the maintenance records and calibration records. I don't know why I don't have that yet. I did ask my staff to reach out and figure out why we don't have that yet. But everything Mr. Malero said is correct. We are still hoping to reach a resolution short of trial. So if the court would allow a brief adjournment of the trial, I think we might be able to get that accomplished.
All right, Ms. Clark, we'll need a new trial date sometime in probably late May or early June if we have a one-day trial date in that time frame. Ms. Clark, are you there? We'll see. Francis is in there or something. So maybe she's on.
And while we're waiting, Mr. Santiago, you need to make an appointment to come see me either later this week or sometime next week.
Are you looking for a date, Judge?
Yeah, we need a one-day jury trial in the end of May or first part of June, if we have that.
Would you like that backed up to anything, Judge?
Yeah, that's probably fine.
June 17th, backed up to William Tones. At 9 a.m.
That would work for me, Your Honor. That's my case anyway.
Okay.
That's fine, Judge. That works for me.
All right, so June 17th at 9 a.m., the court will issue a new scheduling order and vacate all of the other dates.
Thank you, Your Honor. Appreciate it.
Your Honor, do we have a final pretrial scheduled as well, or does the court want to schedule a final pretrial?
Yeah, why don't we? So with June 11th. June 11th at 8:15.
Thank you, Your Honor.
Thank you, Judge.
Okay, and let's see. I had muted Mr. Santiago because there was some background noise causing a little interference. Mr. Santiago, can you unmute your phone? Okay, he doesn't seem to be able to unmute Mr. Molero, so you were giving him some instructions, but I don't think you're going to be able to hear if he responds.
Okay, Judge. Well, we'll figure it out.
All right, Mr. Santiago, you can go ahead and log out then.
Well, you heard that.
Ms. Underwood, are you ready to proceed with Mr. Dillard?
Yes, Your Honor.
And Judge, if I could briefly weigh in on Mr. Dillard's as well, just an issue that I overheard.
Okay, so this is file 24-21905-FHP versus Zachary Ryan Dillard. We're back on the record. Ms. McClure, do you want to place your appearance on the record?
Yes, Phoebe McClure on behalf of the people.
All right, and we do have Ms. Underwood and Mr. Dillard back from the breakout session. Ms. McClure, you indicated you wanted to address an issue.
Yeah, the only thing I wanted to bring up is Miss Underwood indicated she was waiting for a date in district court on, I believe, new charges. So I did look into that, and it does look like there was an error in our system, and those new charges never got to the agency. So we had filed the warrant, but somehow in transit. The warrant never made it over to City of Adrian. I've just sent it over to them though, so now they have it and they can swear to it and we can get him arraigned. So he should have a date fairly shortly. And it was actually only charged on the 4th, so it really wasn't that much of a delay, but I just wanted to make sure that was cleared up, that there was a computer error, but it's corrected now and should be moving along now.
Your Honor, I've explained to Mr. Dillard, while this conceivably has no bearing on the new case would be another violation of his probation, another allegation. Under those circumstances, Mr. Dillard, do you want to plead to the violation?
Yeah.
All right.
Okay, Mr. Dillard, will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
And you are Zachary Ryan Dillard, correct?
Yeah.
Mr. Dillard, do you understand that you have a right to contest the violation of probation charge and to have a trial on that?
Yeah.
Do you understand that you also have a right to contest the contempt for failure to appear and have a trial on that as well?
Yeah.
Do you understand that throughout any trial on the contempt, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yeah.
Do you understand that with respect to any trial on the violation of probation, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yeah.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand?
Yeah.
Do you also understand that you have the right, you do not have to testify at your trial and no one can say anything about you not testifying or hold that against you in any way?
Yeah.
On the other hand, you have the right to testify if you wanted to testify. Do you understand that as well?
Yeah.
How do you plead to the charge that you violated the conditions of your probation by failing to report at orientation and failing to report for your drug screen on December 12, 2024?
Guilty.
And how do you plead to the charge that you failed to appear here in court on January 7, 2025 for that, I'm sorry, January 15, 2025 for that hearing on the probation violation summons?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yeah.
Has anything been promised to you in order to get you plead guilty?
No.
Has anyone threatened you in any way in order to get you plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
You were placed on probation in this case back in December 2024. Is that correct?
Yes.
And one of the conditions of your probation was that you were supposed to report as often as you were directed. Is that correct?
Yes.
And you're also required to do drug testing as directed by your field agent. Is that correct?
Yes.
And the field agent alleged that you failed to report for your orientation on December 17, 2024. Did you fail to report on that date?
Yes, sir.
Did you also fail to do the drug screen on December 12, 2024?
Yes, sir.
And so a summons was issued that directed you to appear in court on January 15, 2025. And you did not appear here in the court on that date. Is that also correct?
Yes, sir.
All right, I'll accept the pleas. Then they've been given understandably, voluntarily, and accurately. Mr. Dillard has had full knowledge of his rights to have competent counsel. I will send this to the probation department for an update of your pre-sentence investigation interview and set sentencing for April 18th at 8:15 a.m. Mr. Dillard, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Yeah.
Can you repeat that date again, Your Honor?
April 18th.
Thank you.
All right, Mr. Dillard, you are all set with court for today. Ms. Underwood, you need to speak to Mr. Raymond.
No, Your Honor.
And you call for Mr. Owen. This is file 24-21808-FH and 24-21890-FH, People versus William Michael Raymond. We are here today for a pretrial on a contempt of court for failure to appear in a violation of probation summons, as well as the underlying alleged violation of probation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Raymond this morning, Your Honor. Thank you.
Right. And where do we stand with Mr. Raymond's case today?
Mr. Raymond has court dates in district court for a new 4-year felony, Your Honor. I believe he has court dates. If not, he soon will. We would ask that this matter be adjourned for 2 weeks.
I looked it up today. He's got court this afternoon there in district court on that case at 1 o'clock.
All right, I'll set it for April 23rd, then at 8:15.
Thank you, Your Honor.
All right, Mr. Raymond, you're all set with this court for today.
Thank you, Your Honor.
Thank you.
Hi, it's Kelly and Judge Sabers. Could we get Daniel Owen in a room, please? Thank you. Bye.
If we're still waiting for Mr. Owen, I'm just gonna run out real quick and use the restroom. I'll be right back.
Okay.
Did we do Sebring?
Sebring is being dismissed.
Okay.
Your Honor, do we have Orozco on the,
No, that I believe got dismissed also.
thank you.
I do have a pickup we're calling from right now on Stephen Garcia. Did you get that info?
I believe I have it.
Okay.
Hi, it's Kelly again. Could we have Stephen Garcia in another room, please? Yeah, Stephen Garcia. Thank you. Bye.
Okay, Mr. Murphy, do you need to speak to Mr. Owen?
I don't, Your Honor.
This is file 25-22208-FH People versus Daniel Jason Owen. We are here today for an arraignment in this case, and we're proceeding today by video conference. First, let me have the attorneys place their appearance on the record. I'm sorry, I think Ms. McClure had stepped out. Nope, she's back.
I'm back now, sorry.
Okay.
Phoebe McClure on behalf of the people.
Matthew Murphy appearing back, Mr. Owen.
Mr. Murphy, does Mr. Owen wish to have the information read today?
No, Your Honor, we acknowledge receipt of the information, the witness list, and the discovery demand from the prosecution in this matter. We just asked for the court to enter and continue a not guilty plea, set this case for a pretrial. I do believe that we'll probably have the case resolved by that first pretrial. I believe the case is probably going to involve an assessment of how much restitution will be available or be requested before then or by sentencing. But so we'll just ask for a pretrial to be set and ask if we could address bond, Your Honor.
All right, I'll enter a not guilty plea for Mr. Owen and set a pretrial conference for April 30th at 8:15. All right, what is it, Mr. Murphy, that you'd like to say about bond?
Your Honor, Mr. Owen is asking the court to consider reducing his bond down to a personal recognizance bond. I do believe that Mr. Owen is not a flight risk. He will reside in Brooklyn. I do believe that, obviously he does have a past criminal history, but I don't believe it's violent, nor is there abscondings. I believe they do involve larcenies. Things of the nature of what he's currently charged with. Again, I do believe, well, we're not trying to downplay the charges themselves, and we understand, obviously, there is concern for the community in all charges. In regards to this one, I think that the main concern for the court would really be his flight. And I don't believe he's a flight risk, Your Honor. Looking at the case, again, I do believe we'll have a resolution probably resolved by the first pretrial. Again, my expectation would be that it would involve how much he can pay ultimately over time with restitution and fines and costs, obviously, whatever we get worked out, which is one of the reasons why I was asking the court to consider a PR bond. Now, obviously, we don't know what the sentence will be, but Mr. Owen wants to give the court and show the court that he can, maintain outside of custody, maintain good behavior, as well as try to get some employment and try to earn some money to pay whatever is going to be owed. Also, Mr. Owen does have custody of his son. His son is residing with his sister right now. That will end come the 15th. So at that point, then what's going to happen with his son? I believe that the mother is currently incarcerated, not for too long. But again, there's going to be an overlap. So I don't believe he's a flight risk, Your Honor. I think when you look at the other considerations, there can be conditions the court could impose. I don't think it's necessary, but GPS tether to monitor him. So I would ask the court to consider a PR bond this time, Your Honor.
Ms. McClure, people have any response?
Just to say, you know, he did have bond reviewed in district court. That modification was denied. There have not been any change in circumstances. I do believe that a PR bond would be highly inappropriate in this case. This was I mean, without an individual being present, it was still a pretty violent burglary of a local business. And Mr. Owens does in fact have a pretty lengthy criminal history, including other theft-related crimes. He was strategic in attempting to get away with this and evade being caught as it relates to this, and how he cashed in those lottery tickets that were taken. And for those reasons, I think a PR bond would be highly inappropriate.
All right, at this point, I agree with Ms. McClure on the issue of bond. It was just recently reviewed. I haven't heard anything in terms of the factors outlined in the court rule that would change what that bond decision was. And in looking at it fresh with my own eyes, I think that the bond is probably appropriately set given Mr. Owen's circumstances, so I did not to modify it.
Understood, Your Honor.
All right, Mr. Owen, you can let the officer with you know that you're done with court for today.
All right, thank you, sir.
Thank you, Mr. Owen. I'll be in touch with you, okay?
Yes, sir.
Hey, how you doing? Hello, Judge.
All right,
how you doing?
You're Mr. Garcia?
Yes, I am.
All right, so this is file 25-52501-PP. Kelsey Garcia versus Stephen Garcia. We are here today for a arraignment on alleged violation of a personal protection order, and we are proceeding today by video conference. Again, sir, for the record, you are Stephen A. Garcia?
Correct, sir, yes.
Have you received a copy of the complaint for violation of the personal protection order?
No, I had, but like I said, this all stems from my house. She's one.
I don't want you to say. I don't want you to say anything right now, sir. I've got to advise you of what your rights are, and I've got to comply with some things before you speak. So just give me a chance to do that.
All right, sir. Sorry.
All right. So we'll send this over. We'll send this over to the jail and have them give you a copy of it. All right. Is there an officer there with you?
Yes, the one that let me in. Yes, sir. Yeah.
All right. Can you stick your head out and let them know that you need a copy of the complaint?
Copy of the complaint. Okay. But it's locked.
I think the criminal docket's done, Judge.
Oh, I'm sorry, Ms. Holly. Yes.
Thank you.
All right, while we're waiting for them to get you that complaint, Mr. Garcia, I will let you know that the complaint alleges that you violated a personal protection order by being present at 1102 Bristol Street and being inside the home. The maximum possible penalty for violating a personal protection order is up to 93 days in jail and or a $500 fine. You are entitled to be represented by an attorney at this hearing and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, I do, sir. Can I have one appointed then?
Okay, do you have the ability to pay for your own attorney?
No, I don't, sir.
All right, I'll put you in a breakout session with Ms. Underwood.
But I do start working on Monday, so.
Okay, I'll put you in a breakout session. I'll put you in a breakout session with Ms. Underwood from the Public Defender's Office.
Okay. Hi, Judge.
We have Ms. Underwood and Mr. Garcia back from the breakout session. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Garcia, Your Honor.
All right, and you know how Mr. Garcia wants to proceed today?
Yes, Your Honor, we would ask the court to enter a not guilty plea on Mr. Garcia's behalf, and then I would like to address bond, Your Honor.
All right, I'll enter a not guilty plea for Mr. Garcia. We'll set this for a hearing on April 23rd at 8:15.
Thank you, Your Honor.
What do you want to say about bond?
Yes, Your Honor. Obviously, I've only seen the one-page document. I have not seen the police report yet on this matter, Your Honor. It is, Mr. Garcia has never violated a protective order before. I believe, has no reason not to show up in court. I believe this is a family issue that is very unfortunate, but I don't believe it's as a result of any violence or anything. I don't believe that's the issue. Mr. Garcia will live with his girlfriend at her address on Chicago Boulevard in Tecumseh, And we believe a PR bond at this point to allow Mr. Garcia to review this matter and with me and come back on the 23rd as appropriate in this matter. And he's going to be working as well.
All right, well, looking at the petition for personal protection order, the allegations that led to the personal protection order include Mr. Garcia's erratic behavior due to drug use. There's an allegation that he punched a wall, making a hole in it. There's allegations that he threatened people. There's an allegation that he broke a window trying to get into the house, and he's apparently alleged, at least, to have been back at the house, was arrested there.
I was arrested where, sir?
Mr. Garcia, please, Your Honor. Perhaps
The
the
allegation that he was at the house
court will
again on April 8th at 8:30, and so I don't think at this point I'm comfortable with personal recognizance bond for Mr. Garcia based on what appears to have been happening at that house with Mr. Garcia at this point. I will set a bond in the amount of $5,000 cash or surety, which I think is more appropriate in terms of trying to protect people's safety, and also with the instruction to Mr. Garcia that if you do get released on that bond, Mr. Garcia, and you go anywhere near that house again, I'm not going to have further bond discussions with you.
I can't, sir, I can't get off on PR because, I mean, this is all stems from
Your
his
Honor,
personal family.
Mr. Garcia, please.
I understand it's a personal family matter. That's why it's a domestic personal protection order. My concern isn't that it stems from family. My concern is what the alleged actions that you've engaged in have been. And the fact that after the personal protection order was entered, you went back to the house. So,
sir, I went back to the house to do, can I explain myself? I went back to the house to do laundry and watch out after my dad.
Mr. Garcia,
he's 87 years old. He's 87 years old.
Mr. Garcia, I've made my decision.
What's that mean?
Mr. Garcia, your bond is
yeah.
5,000 cash or surety.
Okay, what does that mean? I mean, 10%, 5%, what?
That means you could get bonded out for 500.
Okay.
Okay,
I can I get a phone number because my phone is, and then I don't have no numbers. I just need a phone so that I can call somebody.
Oh.
I mean, what about work? I start work Monday. I mean.
I realize that, Mr. Garcia.
I'm not a violent person. I'm not at all. This is.
All right, I've made my
I know.
decision. We're not gonna have further conversation on it, so the hearing is concluded.
Thank you.
Okay, thank you, Judge. Thank you.
I believe that concludes our docket this morning, Your Honor. Thank you.
Yep, that's everything. Thanks.